Ever since news got out that a man in Lindsay, Ontario got charged with aggravated assault after defending himself from an armed criminal who broke into his home at 3 a.m., there's been a flurry of debate over how far the right to defend oneself goes. Should Canadians have the right to defend their homes with lethal force? Well, joining us today to discuss this and more is Lethbridge criminal defense lawyer Cara Lebenzon. She's with the law firm Strategic Criminal Defense. Good to have you with us, Cara.
Thanks, Paul. Good to be here.
Yeah, well, a lot of people voicing anger, of course, frustration that a person getting charged for defending himself from an armed intruder, right? So here's the basics, as far as I know so far about this case. The alleged intruder, Michael Breen, has a criminal record. He was on probation, and there already was a warrant out for his arrest. So not generally speaking an all-around good guy, probably, right? So he's armed with a crossbow, and the homeowner, Jeremy McDonald, wakes up 3 a.m., finds this guy in his apartment. An altercation breaks out. McDonald uses a knife against Breen, and he gets injured so badly, Breen does, that he needs to be airlifted to a hospital. So, did the homeowner have the right to use a knife to defend himself? And if so, reasonable force, right, if that's the standard to the degree of self-defense, how do we define what that is and what isn't reasonable force?
It's a big question. And because this individual whose home was broken into has been charged, it's really going to be a question that's up to a judge or a jury or to the court. I know a lot of folks are looking for answers from members of the legal community, such as myself. And it's because it's such a personal issue for folks around Canada, the safety of their home and their family. But these cases are really so fact specific. And asking, if he had the right to use a knife specifically to defend himself, that's going to depend on a variety of factors that are going to be discussed in his case in court. Now, when people are asking, do Canadians have the right to self-defense in general in scenarios like this, the answer is yes. It is enshrined in our criminal code under Section 34, and you alluded to the test based on reasonableness. And yeah, I'll get into that a little bit more. That's exactly where it's laid out. So it's hard to answer the question yes or no. The real answer is it will depend on the court's analysis in applying all the very specific facts that occurred in this scenario to what the criminal code has to say about the test for self-defense.
Yeah, I guess what's reasonable, right? And again, until you get all the facts, you don't know for sure. Okay, so this is at nighttime, right? So you're into somebody else's home, so it's dark, right? But the guy had a crossbow, so he's armed. So if he saw that, and if he felt threatened, and understandably, most of us would, I would think, right? Why would a guy have a crossbow? He's not there for target shooting, right? So that would make sense, wouldn't it, though? Would be reasonable, would it? If he feared for his life, he saw the guy had a weapon, so to grab a kitchen knife or whatever to defend yourself, would that be normally considered reasonable by a judge or a jury?
So you have outlined some of the actual factors that are listed in the criminal code that the court will assess. For example, what was the nature of the threat? Were there any weapons used, and what kind of weapons were there? Other biographical factors, such as what is the size of the intruder opposed to the person defending themselves. Other things like the duration, how much force was. The key here is proportionality. Was the response to the threat proportionate? And I've been watching the news a lot about this and hearing what folks have to say. And one of the big things that comes up is when I'm afraid for my life or for my property and my family and my home and someone's intruding, I don't have time to get out my criminal code that I don't have a copy of.
Exactly.
Making this assessment, right? That's not natural. But the law and the courts don't expect people to go through this technical assessment on the spot. There is some recognition that everyone has a different subjective response to a threat or to danger if it happens to them. And so that is going to be taken into account in court in the analysis of whether their decision of how they defended themselves is going to be lawful.
Yeah, quick question that just popped into my mind. I know I've talked to police officers in the past, and I'm not sure if that's still the case, but he was telling me as a Canadian police officer that they're trained, in a situation where they have to draw their gun, and the person doesn't respond to threats of drop the weapon or whatever, so they're being approached by somebody with a knife or a gun, whatever the case may be, there's lives in danger. They're trained to actually shoot to kill. So not to wound, not proportionality, but to get rid of the threat, to keep everybody else safe. So it sounds like those same principles wouldn't apply to the average citizen, though.
Absolutely not. You're talking about a whole other area of the law with regards to police powers. But it is interesting that you mentioned that because a lot of people, I think, naturally compare what happens in Canada to what happens in the US because it's so close to home. And the US is notorious for their very broad, right to bear arms, right to stand your ground, which is really a lot more broadly acceptable of people going to the full extent to protect themselves. That sometimes does end lethally. And so it's natural to make those comparisons. But what's important is that really that reasonable factor, because even though it's kind of annoying, people want to know answers and they hear this word reasonableness and it's so vague.
Yeah.
What that part of the test really does is it protects and safeguards us from extreme situations. For example, if the law was that you could protect yourself to any extent, regardless of the outcome, maybe you have a neighbor who stumbles over to your place by accident. And if the law was you could just take out a weapon and defend
Yeah.
yourself at any cost, that would open the floodgates to all sorts of problems. So, really, what this test does is it enables people to defend themselves, but it also creates limits, right? And so that's important.
Yeah, I would agree. We often do hear cases from south of the border, typically, where again somebody gets shot and maybe they were just, at the wrong address at the wrong time. I just heard about a case here a few days ago where a teenager was shot by his own family, coming home late, and they thought it was an intruder. They shot their own kid. I mean, it breaks your heart, right? So, a little common sense goes a long ways, right? And more details are coming out about this case now as well. Now, apparently, these two men knew each other before this incident. I don't know to what degree, were they friends or just kind of acquaintances? Did they work together before? Who knows, right? But that could be a significant factor, I'm assuming, right? Does that change anything?
Absolutely. And again, that is codified in the section of our criminal code. And those factors that we've talked about is the nature of the relationship between the parties. That's also something the courts will look at because if we're trying to prevent vigilante revenge type incentives that are involved in that self-defense. So if he knew the person, if he had other motives to go above and beyond what was necessary in the circumstances to defend himself, because of that, then that's something that the court would take into consideration, right? For example, if somebody comes in with a weapon and he had a knife, I don't know the exact fact, they'll come out in court. But if he were to have stabbed the intruder and he was subdued, that's different than knowing the person being extra angry at them because of a prior relationship or fight and going above and beyond. I'm not saying that's what happened in this case at all because we don't know yet, but that would be an example of why their relationship would come into play.
No, for sure. Yeah, it makes sense. Now, you mentioned earlier that even things like the size of the intruder or the size of the defendant, the person at home, the age, the physical capabilities of the folks can be a factor as to whether the force used was reasonable or not. So, for example, we hear the argument that, okay, if the intruder pushes you, you can't grab a baseball bat and hit him in the head. And initially that makes sense. But just pondering that, if you are small and he's huge, you're worried about your safety a little more than maybe the average person is, right? So would it be then reasonable to, yes, grab a baseball bat that happens to be sitting there and smack him in the head? To me, that I guess makes more sense, but what do you think?
We'd have to leave it to the judge. I know that's not the black and white answer that people want, but yeah, it's certainly relevant. Again, it goes back to that subjective belief of the threat and the level of threat and doing what is reasonable in the circumstances and what's proportionate to defend yourself. And if it was a smaller person defending themselves against a bigger person and they used a means that was necessary to defend themselves, then that's something that the court would consider. They might find that it was reasonable, and there might be other factors that they found were not reasonable.
Now, because the definition of self-defense is quite subjective, is it possible that police sometimes lay charges against the homeowner as a precaution of sorts and then kind of, like you say, leave it to the courts to figure it out later?
Absolutely. And it's really interesting that you bring that up because in Ontario, where this case happened, the police, I would say, have much more broad discretion when laying charges. Whereas in Alberta, if this were to happen, the Crown prosecutor often gets involved at the earlier stage and has more of a say in screening whether the charge
Ah,
be laid. So there's more of a Crown prosecution involvement in the laying of the charges in Alberta. And so while in Ontario they would be charged, and then you're right, the self-defense issue would only be brought up in court. This person might be held for a bail hearing. There might be all these other procedures that they'd have to go through. That's still not to say that the prosecution in Ontario might withdraw the charges before it went to trial. That's very possible. But in Alberta, there's a little bit more Crown involvement during the laying of the charges process.
okay, good to know. I did not know that. What about the right to defend your property? So the intruder isn't in your home, but it's maybe on your property trying to steal something, that sort of thing. What can you do and what can't you do in that case? I mean, I'm assuming you can't just get out a gun and start shooting at them, right?
That's right. It's very, very similar analysis. And, if you don't feel like your life is in danger and, somebody's trying to take your property, then that same standard is going to be applied. Are you using reasonable mechanisms in the circumstance to defend your property, or have you gone above and beyond? Maybe you've used means that are more appropriate for if it was a home invasion or if your life was in danger. So again, very fast, specific, and similar test though.
Right. And we have a number of politicians, of course, speaking out on this. It's great political fodder, saying that we need to change our laws to be more favorable to the homeowner to be able to defend themselves without worrying about getting charged. And I think most people emotionally agree with that, right? But is that going to help? Your thoughts on that?
Yeah, so anytime we have an issue like this that really speaks to people's emotions, like I mentioned at the beginning, a very personal issue, keeping ourselves, our homes, and our family safe. How more personal does it get than that? Our home is our castle, has been said. However, we have to remember that it's easy for politicians to use these kinds of issues to garner support and popularity and votes, and it's often that they don't really delve into what the law really is. I haven't heard any of the politicians give a concrete on exactly how they want to change the law, because this self-defense law in the code actually was amended a few years ago, I think, during Stephen Harper. So um, it's my opinion that this is a comprehensive and appropriate test that while it's unfortunate that somebody who was in a situation of being a victim might end up getting charged, there are mechanisms to get down to the bottom of what happened. And
Okay. Yeah. Well, it'll be interesting to see what other details come out once it gets to court. And might make more sense to all of us once that comes out. But okay. Well, I really appreciate your time. Thanks so much, Cara.
thanks for having me, Paul. Always a pleasure.
Oh, you bet. Cara Lebenzon is a Lethbridge criminal defense lawyer with the law firm Strategic Criminal Defense.